All right, everybody, I'm super excited. We do this every year at the end of the year, kind of a questions and answer session. So I never have any idea what you all are going to ask me. If you have questions, go ahead and put them in the chat box. That would be awesome. I have a whole bunch of questions that came in before today's program. To introduce myself, I'm Emily Kile. I'm an attorney here at Mushkatel, Gobbato, and Kile. So we have merged Kile Law Firm and with Mr. Mushkatel's firm. So we now have an office in Sun City, but we are still here in Scottsdale in the office on Via de Comercio as we have been. Our phone number is the same. Emails will still get to me, but you can use the Emily@phoenixlawteam.com or the Emily@KileLawFirm.com. Either is fine. And so I've been practicing for about 30 years for those of you who know me. We do estate planning, guardianships, conservatorships, special needs planning, all text planning, all that kind of stuff. So I have my great slide up, though, to remind you that even if I represent you, and I recognize many of the names on the attendee list here, for purposes of today, I do not represent anybody. So obviously, you all know it takes more than a chat session to ask a question and get a full answer. So please make sure you get appropriate advice for your question, but hopefully I can send you in the right direction. All right. So the first thing I want to tell you, and then I'm going to get to my huge list of questions that I appreciate you all sending to me, is to remind you to update your estate plan. Okay? Don't just do it and forget it. We do a lot of trust administration, and we find out that people don't speak to the people who are beneficiaries anymore. Nobody knows how to find them. Accounts that were listed in the binder don't exist any longer. And so a lot of time and effort is spent looking for stuff that would be much easier to find if you had made it easier for people to find by making sure that that stuff is available in your estate planning binder. And for your beneficiaries, you know, what you probably did 20 years ago, 10 years ago, maybe even last year, maybe those aren't your favorite people anymore. Those aren't the people who should be managing your stuff. So please do your updates. Make sure you're reviewing your documents regularly. Everybody laughs at me, but I pull out my own binder every New Year's Day. It's an easy day to remember, and I can look and see who's been naughty and who's been nice, and so who I should continue to leave in that binder as a beneficiary and who it's time to move on, or who are the people that I trust if I was in a coma to manage my money and myself. So just a reminder on your estate planning. All right, so I'm going to just plow through the questions that I have, unless I get some in the chat box, and then I am sure that I have some other things to tell you to make sure that we get those covered as well. So, oh, there's going to in the Q&A as well. Okay, perfect. So both in the Q&A or the chat, whichever it is that works for you. So I'm going to start with the kind of basic questions that I got. There's a whole series of them, but I'm just going to start with a couple of them because I think they're nice in general, and then I will get to your Q&A and your chat questions. So the question is, as my parents' health and cognition wanes, I feel somewhat overwhelmed about what will need to be done and on what timeline when the parent passes away. All right, well, you must be on the right path if you're feeling overwhelmed already, because it's probably going to get more overwhelming. Oh, I've been told the chat is disabled. Well, I don't know how to enable it, so just put stuff in the Q&A and we'll watch that. So this person said, I have financial and healthcare power of attorney over my parents, and I serve as co-trustee. That the person's name is on the property tax statements on the house and is curious about whether the person should be on the deed. So hopefully that house is titled in the name of the trust. And so when mom and dad pass away, become incapacitated, you as the co-trustee have the authority to do what you need to related to whatever has to happen with that real property, as well as any other accounts that are titled to the trust. Your power of attorneys terminate when the principal, the person who signed the document, passes away. So then people get really concerned, of course. Well, the idea is you don't have to make decisions for an incapacitated person anymore, so you don't need that authority. The trust document would control anything that's titled to the trust or where the trust is a beneficiary. So if there is a bank account and it's pay on death to the trust, then you would bring a death certificate to the bank, and after many trips and many hours at the bank, they eventually would move the money over to a trust account and allow the trustee access to that account. The same would be true for that house. So if the house has the name of the trust on it, then whoever the trustee is should follow the trust document, which I like to think of as the rule book for the trust, and they would do what they need to, whether it needs to get sold, somebody has a right of first refusal, the personal property needs to be taken care of, all of those things. But the financial power of attorney does terminate when the person passes away. One of the items that we see all the time that ends up not titled in a trust with nobody having authority would be the safe deposit box at the house. People less and less frequently are opening safe deposit boxes, but many older folks still have those. If you are not listed on there as a signer to get into the box, when your person passes away and your financial power of attorney is no longer usable, you will not have access to the box. Some of the financial institutions will allow you access just to see if the original will is inside the box, but they will not allow you to take anything out. If the box is titled to the trust, then again, as trustee, you're going to have access to get into that box, which will be fantastic and make life much easier. Otherwise, you may end up needing a court order. You might not have to do a full-blown probate, but you may need a court order in order to be able to access the box. If you know the box number, you have a key, and I hope you know which branch it's in. That also will reduce fees and make things faster because they won't have to have somebody come in and drill the box for you. So this person said the parents' bank accounts are in the name of the trust, and I am a signer as a co-trustee. Beautiful. Whether mom and dad are incapacitated, perfectly fine, or when they pass away, you should continue to have access to those accounts. And I would strongly recommend that you keep very good accounting records so the other people who may be beneficiaries, you would be able to show them that the funds were used appropriately during your time period as trustee. And you must provide notice to the beneficiaries, which might just be mom and dad, depending on how things are set up, that you are a trustee and whether or not you're intending to get compensated for your services as trustee. The person says, is there anything that needs to be done preemptively, the three things that we just talked about, in order to simplify matters? Make sure that you have reviewed the trust documents, and so that you understand, and most importantly, your parents understand, not only that you're in control when the bad thing happens to them, but are they really the proper beneficiaries that were supposed to be on there? Again, do we have some percentage going to a brother, a sister, or a friend that we don't have any contact with anymore? And do you have a full and complete list of where all the assets are, and any assets that are not in a trust, like retirement accounts, IRAs, 403Bs, 401Ks, that those all have actual beneficiaries listed on them, and that you have copies of the beneficiary forms. The retirement companies will only talk to the person or entity that is listed as the beneficiary. They will not release information as to who the beneficiary is. So when the parent dies and now we have an IRA, if you reach out to the IRA company, but it turns out that you are not the beneficiary, they will simply tell you that they cannot provide you with any information. So really important to see what those look like. The same for life insurance. So before I move on to the other questions, of which there are many on my list, one of the questions is, what's the best way to pay for funeral expenses? I am the POA and have access to the checking account. Is it legal to write checks on account if he has passed? So the answer is, again, your power of attorney should terminate when your person passed away, so that would terminate your authority to access that checking account. I don't know what the amount of the checking account is. I don't know whether there's a beneficiary or a joint owner. If there's a joint owner, the joint owner would continue to have access to the account. If there is a beneficiary on the account, then the beneficiary would receive the funds. If the amount that's at issue is more than $75,000 in all of the bank accounts, so all of the money aside from the real property, then a probate may need to be opened in order for you to access that checking account or whoever is going to get appointed as the personal representative. I think a few more facts to figure out that authority and who can access the account. A year ago, transferred the deed, power of attorney, health, and finance concerning my wife with dementia in preparation for possible all-tax. She's involved with a personal injury lawsuit. Can the settlement come to me since I have POA? What will the state want? So I'm going to say pursuant to the rules instead of most of the time. When we have an incapacitated person, you will need probate court approval to get that lawsuit approved. And then you can certainly manage the money as the power of attorney unless the court says that you need some kind of a conservatorship. And so that would all be done in front of the probate court via a petition, we hope. And I hope that your personal injury attorney is walking you through that process. There is no transfer penalty for all-tax purposes. All-tax is Arizona's Medicaid program. It stands for the Arizona Long-Term Care System. So that's the program that covers nursing home, limited in-home care, assisted living, skilled nursing facilities, day programs, all kinds of stuff. And there are income and asset limits for that program. And any asset, when the application is submitted, any asset that is in either spouse's name or in a trust that benefits either spouse has to be disclosed for the state to then determine whether it's a countable resource or it is not to impact eligibility. So in this circumstance, in the event that money is going to come to one spouse, who's the one who is on all tax, all of that should be figured out in the court proceeding to give you authority to do what you need. But again, there are no transfer penalties, meaning that there are waiting periods for transfers between spouses. And if the money has already come in for the lawsuit and the person was already on all tax and then it's transferred to the well spouse, the one not on all tax, there would be no disruption to benefits and again, no waiting period or penalty for having done that, even though it must be disclosed to all tax. So I hope that's helpful. So another question is, I'm co-trustee of the living trust. I'm going to assume for parents. I don't know if the bank accounts are included in the trust. Yes, the golden question. So most of the time the statement, or if you have online access, it would have the person's name, comma, TTE for trustee, and then we know it's a trust account. If it has just their name, then it is probably not a trust account. And if you are the trustee and you bring whatever documents, either a death certificate or letters from the doctor saying the person's incapacitated, whatever allows you access to the financial institution, again, after a long waiting period, after probably many trips to the bank, eventually they'll be able to tell you how it's set up and therefore whether you can access it as trustee or whether a probate or other small estate affidavit process might be necessary to be able to get access to the account. Again, I hope that's helpful. We move from one county to another, as all we need to do is notify the new and the old county of the address change and then file our annual report. So I am presuming that this person is guardian over an incapacitated person. And so you have to file, if it's a different county, a change of venue motion so that the file can be moved to the new county. That way, if court-appointed counsel needs to be appointed or reappointed, they have somebody who's local in that county. So yes, you have to do an address change, but typically you have to also file a change of venue motion in order to get the file moved. There's a fee for that, which I don't remember off the top of my head. It's a couple $100, I believe, that goes along with that so that they can transfer the file from one county to the next. Congratulations on your move. I hope you're enjoying wherever you now live. That's great. So it says, even if an adult child is listed on the parent's checking account, if there's more than 75, they can't access the money. So in whatever industry you practice in, just like being an attorney, words have very specific meaning. So if you tell me you're a signer or a power of attorney on an account, typically that authority terminates with the death of the owner. If you are a joint owner on an account and the other person dies, you own the account. You wouldn't need a court action, a probate, or anything, because if you're joint on the account, you now own the money that's in the account. If it is payable on death, again, death certificate to the bank, lots of time, and eventually they will hand the money over to you because you are the beneficiary of the account. If your person is alive and you're an agent or a signer on the account, you have to make sure you're using all the money for the benefit of the owner. If you are a co-trustee or the trustee, again, you have total access to the money regardless of death, incapacity, or the person is living and fine. So if you are a signer or a power of attorney, that terminates when the owner passes away, and therefore you would not have ongoing access. If you are a co-owner, then yes, you would continue to have access for that account. The next question is, what are the tax implications for assets in trust, both before and after their death? So along with my disclosure on the screen that I'm not really your attorney right now, I am definitely not your tax planner. I am definitely not your accountant. I will give you super general information. So the grantor, the one whose money it was, when they put it in their revocable trust, there are no tax implications. When money comes out of a trust to the grantors, unless it's retirement, so pre-tax dollars, there would be no tax implications. If there are retirement assets and the trust is the beneficiary of those, somebody's going to pay income tax. So whether it's paid at the trust level or is paid to the final beneficiary of that IRA will depend on how the beneficiaries are set up and how the trust is structured. That would be income tax. The folks who inherit from the trust, so let's say my father passes away and he leaves me $10,000, there's no tax on that typically unless it's a retirement account. And typically, I would get the new date of death value if, for example, that was appreciated stock or real estate. So it completely depends on what the asset is, whether the asset is coming out after death and who it's going to. Is it going to the grantor or is it going to other beneficiaries? Whether or not it's income taxable. The estate tax, I think, is about $13.5 million. That's the exemption. So if you are inheriting from an estate and the total value of all of the assets are less than that, approximately $13.5 million, there would be no estate tax because Arizona doesn't have a separate estate tax. We just look at what the feds have. So most of the time, the only tax implications for the beneficiaries are going to be income tax related to distributions from traditional IRAs, 401ks, SEP plans, everything kind of but Roth IRAs. So I hope that helps you. You should definitely seek the advice of a tax professional. Question about food assistance eligibility, the SNAP program. Is money in a 401k, a special needs trust, or an ABLE account count towards eligibility? So the funds in the special needs trust and the ABLE account, to my understanding, are not deemed to be included assets, although everything has to be disclosed at the time of application or anytime there's a change in financial circumstances. So if you qualified for supplemental nutritional assistance and then somebody funded a trust for you, or you received an inheritance that went into a first-party special needs trust, those assets should not count against you for that program, but you still have to disclose to DES that in fact you received those funds. My understanding is that money in your 401k is an asset because you have direct access to those funds. And so again, that would have to be disclosed. And again, it's my understanding that would be a countable resource towards the asset limit for that program. And then a person said, thank you. So that's not actually a question, which I don't have to answer, but thank you. Thank you for being here. We have plenty of time left, and I have lots more questions on the sheet that my staff was kind enough to put together. My understanding is the taxes on a special needs trust are quite high, higher than regular tax rates. Again, not a tax professional, but tax rates in general are higher because trusts are taxed at the highest tax rate after a very little bit of income. So we all know for our personal income taxes, it's a graduated rate. So, whether it's the 10%, 15%, whatever the percentages are up to whatever the top rate is, 40% or whatever that income tax rate is. But trusts only have basically one, and you go straight to the top. So I don't remember what the amount is that you have to have an income for the trust to pay tax. But once you get over that threshold, it is true that you bump right to the front of the line or the back of the line, however you'd like to see it, and you end up with the highest tax rate that is available. By the same token, if you are allocating from an accounting standpoint that all of the income is being pushed to the beneficiary, so that's an accounting issue. You pay for the vacation and the cell phone bill and all of these other expenses from that trust. And so you then account for that came from income and not from principal. It may be that then the beneficiary is paying the tax potentially, but their rate is probably much lower than what the trust tax rate is. But again, I would highly recommend that you talk to an actual person with the initial CPA behind their name, not a me with just a lowly ESQ after my name. Great tax questions, though. Today's Zoom is being recorded, and it will be on the YouTube channel for Mushkatel, Gobbato, and Kile, along with all of the other, not all, many of the other webinars and recordings that I have done in the past. You should find all of that on our new YouTube channel, even though some of them are older recordings. But we still have plenty of time. So I'm going to, till I see some more questions in there, I'm going to continue to go down my list. This is so much fun. I hope you're having fun. All right. So let's see, this was again about the power of attorney ending. So one of the questions is kind of like, how quickly do I have to get started if I am the trustee and we're going to say parent died, and I'm the trustee, other parent is deceased or they were divorced? What do I have to do? So being a trustee is a huge responsibility. You need to make sure that you are gathering the assets, you're doing your best to safeguard the assets, you are inventorying the assets, and that you have to provide notice to the beneficiaries, which includes a copy of the trust document or the sections of the trust that have to do with that beneficiary. Most of the time, I find that if you only provide a redacted trust that only has the provision for that one person, they are sure that you are keeping secrets from them and are going to ask for the whole thing. And if this went to litigation, and my partner, Mr. Mushkatel, will correct me if I'm wrong, most likely the court's going to order that you turn over the whole trust. So our position has pretty much been we just provide the trust document. I have had clients in the past who have said, under no circumstances do I want anybody else to see any other provision because I don't want anybody to have hurt feelings about I left this much to this person and I left this much to this person. But again, if it ends up in litigation, most likely the whole trust document is going to become known to all of the beneficiaries or heirs, so they can make sure that the trustee is doing the right thing and is protecting the people who need to be protected. You can do lots of pre-planning, so you can prepay for funeral expenses, you can prepay at the mortuary, you can even prepay for the service, all of those things. And it's nice if you, as the person who is going to pass away in the future, like all of us, if you've done that, because it's one less thing that somebody else has to deal with. And as I said before, if we don't have a trust on the bank account or a joint owner, then somebody's paying out of pocket for those expenses until people get access to the money and can get reimbursed. And for lots of families, that's a huge burden to have to pay for those things and wait to get paid back, especially, if it's on a credit card and you're paying 20% interest because you don't have the funds to pay off that bill right away. So just something to think about. Anybody who's listened to me talk about estate planning, I can't stress enough organizational skills. If you have your binder on your shelf with all your estate planning and you haven't told the people who are your decision makers, hey, if the bad thing happens to me, I have you listed, and this is where my documents are going to be kept. And if you don't have a list of what the assets are, I have this account at Wells Fargo and this account at Bank of America and this with Morgan Stanley. Here's my financial advisor's contact information. These are the doctors that I typically see. These are the medications I'm allergic to. Kind of information that is super helpful when you can't talk to us anymore to say, these are the things that we need to take care of. So just keep that in mind to be very practical. The other thing is if you have personal items and you feel like there might be some dispute about who gets what, you could do a list and say, you get this bracelet and you get this necklace, or you get the car. You can't put money on those, but you can put stuff. Speaking of cars, there is a form you can get through the Department of Motor Vehicles here in Arizona that you can fill out and say who you want your car to go to. It's free. If you just Google the Arizona Motor Vehicle Department beneficiary form, doesn't even require a witness or a notary. You keep that document with the rest of your estate planning documents and the title to your vehicle. And when you die, the person who's listed on that form would take that form, your death certificate, and the title to the DMV. And now they will get a title in their own name, and then they can sell it or keep it or do whatever. And that would be a great streamlined process if you have motor vehicles and you know who you want them to go to. Or you can fill that form out and say that it goes to the trust. And then the trustee would get the title in the trustee's in the trust name, and then the trustee could deal with what to do with the vehicles. So another question is, a friend has an adult who has an undiagnosed special need. The adult child likely has some undiagnosed disabilities. What resources would you recommend for the parent beyond the regional centers to access whether there is an actual disability and that this young adult could qualify for services? So this person lives in California, which I don't know anything about. But there is a website, I think it's usa.gov, it used to be benefits.gov, that you can go to, anybody can go to in any state, and it runs through a series of questions about disabilities and income and assets and all kinds of questions. And then at the end, we'll say something about, these are the benefits we think you would be eligible for, and here's how you apply for them. So it can be a really nice screening tool. In the past, we have had somebody from an organization called National Care Advisors speak. So they don't do diagnoses, and I'm not affiliated with them or have referral fees or any of that, but they are nurses and other professionals across the country who can help set up services. They can help determine what might be appropriate. They can do care assessments about what kind of care should be in the home with that person. They can do visits, so all kinds of services like that. Not free, but a very nice service to have kind of those kind of professionals around the country. It is free to apply for benefits through Social Security. So if we have somebody over the age of 18 and the question is whether they might be eligible for SSI, Supplemental Security Income, that's a benefit where somebody doesn't have enough work quarters to qualify for Social Security disability benefits, and they have assets of less than $2,000 in any account other than a special needs account or an ABLE account, and their income is very low, may qualify for that SSI benefit, which pays just over $900 a month in 2024. And that person, if in Arizona, will be automatically eligible for access-free health insurance. So lots of times people, maybe their kiddo is on DDD and all-text benefits, the Department of Developmental Disabilities and the Arizona Long-Term Care System, and they're getting respite care and therapies and maybe group home day programs, maybe some employment assistance, and they think they'll automatically be eligible for SSI or vice versa. So DDD and all-text you can get at birth or any time through. SSI, typically you would not apply until after that person is 18 years old, because if their parents have income, if their parents have assets of more than 2,000 accountable resources, that child will not be eligible for benefits prior to age 18. The eligibility criteria for SSI is very different than the eligibility criteria from our Medicaid programs. So Medicaid DDD all-text are looking at functional ability and IQ for the kids. For SSI, they're looking at the ability of that person to be employed on a full-time basis with no extra accommodations or help at the job at least a minimum wage job. That's my assessment. I think there's actually a number, like $1,000 a month or whatever the number is. But if you think about it that way, those are the people who are going to be eligible for SSI. And again, they have to be under the or over the age of 18 if their parents have any assets. So that's another way to determine what the disability of this person is, assuming, again, they're over 18 years old and don't have much work history, haven't been able to have a job. The other thing about SSI is that a person can go on a work trial period for twice for 9 months each, and they don't get removed from SSI. So they might not be collecting any money, but they're not disqualified. The reason that's important is lots of folks who do qualify for SSI are what I would call serially employed, right? They have a job for a few months, their anxiety or behaviors or whatever's going on for them become more and more unmanageable due to the stresses of working. And so then they lose that job or they're no longer able to maintain it and they leave. And then they get another job and maybe this keeps happening. They may be able to maintain their SSI, so in the interim periods, they will be back getting that 900 and change of money from Social Security. And going back to the question about what are the resources to find services, the pediatricians and the doctors who see young adults should also be able to provide some assistance in that direction. Any of the government agencies are free to apply for. So many of them, as I said, have a medical criteria and a financial criteria. And most of the time you can see if the person qualifies medically before you have to worry about what the number is. Some states, ARC, the nonprofit ARC, have really good resources. Arizona is mostly for legislation, policy change, not quite so much for services, but lots of other states. I know, for example, Texas, their ARC is very involved in providing services in the community. So there are usually many nonprofits that are out there that can help figure out if somebody might qualify, what they might qualify for, or kind of send them in the right direction. This question is, what age do you suggest your young adult child becomes power of attorney? My daughter's 23. Well, first of all, I can't believe she's 23, knowing the writer and having started this when she was much, much younger than that. But they just have to be over age 18. And I think after that, it's really up to you in terms of what you think that person's maturity is and how much you would trust them. As depressing as it is, I think if I was in a coma and my agent and my trustee were out there doing their thing, when I wake up, am I going to be horrified? Or am I going to think, oh yeah, I made a really good decision. I feel comfortable with what they've done. I'm sure they were looking out for me. So that's how I would judge it, not just by age. By the same token, if you have named one of your kids and they have triplets, and one of those triplets has some special needs, and they're having some marital issues and they're not very financially secure right now, it might be a bit much for them to take on the role of also trying to help make some decisions for you. So look at the whole scenario. Lots of times people ask me, do they have to live close by? No, and in our world, like today, we can be virtual, we can talk to doctors virtually, we can do lots of banking online. And I would hope that the person that you've named, if you were in a really bad situation, would actually travel to see you. For those of you who bank at local banks that don't have a national presence, it might be slightly more difficult for that person to manage those assets from afar when there is no branch somewhere else. Oftentimes now, due to all the non-terrorism acts that the federal government passed many years ago, typically you have to be in person with your ID rather than just holding it up to the screen and showing that you're you. So that would be the only thing that you would want to think through. And to make sure that, there's sufficient assets in your estate to fly that person out, because they shouldn't bear that cost when the bad thing happens. So one of the other questions on my list, since I don't see any more in my chat, is what notifications have to be made when the bad thing happens to my loved one? So for Social Security, typically the mortuary is going to let Social Security know that the person has passed away. And Social Security has the ability to go right into the bank account where the deposit was made and pull it right back out again. The same for veterans benefits, so don't be surprised if the money went in and then the money came out. The mortuary is not going to contact the VA. So if your person is getting a pension of any kind and they have passed away, you want to make sure you contact them in writing to let them know that your person has passed away. There may be a refund that needs to go back to them, or it may be that benefit goes then to the spouse of the veteran, or there are some benefits that can go to a disabled child through a special needs trust for the benefit of that disabled child, regardless of age. So you'd want to understand what are the tail, so to speak, on those benefits. The same with regular pensions through the state retirement system or other pensions that you have, to really understand what happens when I pass away. Does 75% go to my spouse? Does none go to my spouse? Is there the authority for me to leave it to a disabled child when maybe the plan is generally it terminates at my death? So make sure you're asking those questions. On here it says, I've heard that I should not notify the bank because they're going to freeze the accounts, which is going to stop access to funeral expenses, ongoing money in and money out. So oftentimes the bank is notified. I'm not even sure how, to be honest, but I think it's when the mortuary notifies Social Security, Social Security takes the money out, and then the bank stops the account, assuming that there's been a death. Having just been appointed recently on a trust, it is absolutely true that once they find out, the account is in frozen status, and any deductions or no money in, no money out, even on your auto payments. And so that can be very problematic when your account was paying the mortgage. And now the account has been frozen, and so that mortgage payment is not being made. So it would be important to, once you have that death certificate and we know who's supposed to be in charge, to make sure you get to the financial institution so that all that, the frozenness, it can melt away. And so even if the accounts are going to stay right there while you're trying to figure out who gets what and what bills do I have to pay and forwarding the mail and all the other things, that at least those mortgage payments, auto deposit or debits for the utilities can stay on at the house. All of that stuff can keep going. And then you can go back and reallocate to the beneficiaries if, as a result, the house passed to somebody else, maybe through a beneficiary deed on the house, yet the trust is still paying the mortgage. You can reallocate, hey, the trust paid $5,000 during the administrative period, and so now that needs to come off your share, whatever it is that needs to happen. So do be conscientious about that. Oftentimes financial planners are super helpful because they're aware of the accounts, they know who the people are, they understand the players. And so again, in your estate planning binder, having that information in there is really helpful. In the binders we prepare, we have a sheet that's contact information, which includes a section on who's my doctor, who's my CPA, who's my attorney, who's my financial planner, and then a section of maybe contact information people wouldn't know, like I left something to my stepson, but nobody else in the family knows my stepson. So what's their name, address, email address, phone number, and then obviously make sure those get updated on a regular basis. So that we can find people that that even your family might not be close to or hasn't had any contact with in a long time. And maybe they don't know the code to get in your cell phone where all of our lives lie. So you might want to figure out some way to get that information to the person who would take over so that they can access your cell phone to get contact info. And we all know you can change it. So if you picked Joe to be your agent and he turns out to be an unpleasant person, you told him the code to your phone, just change the code to your phone and any other, obviously, usernames or IDs that you had that you disclosed to that person. Let's see. So questions about trust administration in terms of providing inventory and assets. So the Arizona Trust Code has timeframes for these things. You have to provide notice to all the beneficiaries with a copy of, again, the trust or the provisions that relate to that person. And then they have to be given a 4-month time period to contest the validity of the documents that have been provided, or we hope they sign a consent so that we can get things moving faster and don't have to wait for all the consents to come back, which again is a big problem when we can't find who the beneficiaries are. Deciding about what to do with the house. So when you are with your estate planning attorney and you're talking about 25% to each beneficiary, but you know that your son lives in your condo, give some serious thought to, do I want it to be sold? And now that person who maybe has had a hard time being self-sufficient, now they have no place to live. Do you want to say they have a right to stay there, but they pay all the utilities, and when it's sold, it's divided equally? So think through practically what's happening in your family and what you want to do with the assets. The other thing is that if you want to leave money to somebody who has special needs and might be receiving benefits through the state or the federal government that are dependent on income and assets that an individual has, or if you have a loved one who has special needs and you have a parent who wants to leave money to that beneficiary, please make sure they understand what the impact would be if they leave that as an outright gift, even if it seems small, even if it's a couple $1,000s and that seems small to them. It may still have an impact. So while none of us want to say, hey, are you leaving anything to my kid? You might want to just send an email that says, hey, I met with my estate planner and I did a special needs trust for Joey. If you're going to leave anything to him, could you just please leave it to the trustee of the Joey Special Needs Trust? And this is really important because oftentimes your parent's estate plan or no estate plan says that it goes to you, but if you're deceased, it goes to your descendants, not to your spouse, but to your descendants. So if you pass away tragically and it goes to your descendants, and one of your descendants is a descendant who receives DDD, Altex, SSI, food stamps, all of those programs, then it's great that they got money, but now we have to do a first-party special needs trust, which probably is going to require court approval and is going to have a payback to the state when that kiddo passes away, all of which can be avoided if they had just said, it goes to my kid, if my kid's deceased, to their descendants, but if the share goes to Joey, it goes to Joey Special Needs Trust. People often ask me, why would you ever want to do a first-party special needs trust, the kind that has a payback and you have to provide a budget to Altex and all of that stuff? Because we have situations where there's a probate and money goes to a kid who's on benefits or an individual on benefits, or the kind of plan I just said, where we didn't expect mom or dad to be deceased, and now money goes down to that person, personal injury settlements. So there are various scenarios in which money will end up in the name of the person on benefits, and then to keep them on benefits, those funds need to go to that first party special needs trust. So do what you can to avoid it by doing a third party trust, which doesn't have a payback. You can leave the money to anybody you want when Joey dies. Lots of people can name that same trust as the beneficiary. So many of you have heard from me, my niece Marissa, who's on one of the videos on our YouTube channel, she's adorable. I drafted a special needs trust so that her grandma can leave money to the trust. Her parents don't have to draft another trust, so they can leave their money that goes to Marissa to that trust. My estate plan can say the share for Marissa goes to that trust. All of it just funnels into one bucket. So as long as everybody agrees to who the trustees are going to be and who the remainder beneficiaries would be, if the beneficiary, Marissa, would pass away, you can put it all in one special needs trust. And so that works really well and is a really inexpensive way to get the whole family on board. One of the questions here is, what are some typical or avoidable mistakes people often make when they have a disabled child or a special needs trust? So I think one of the big things is that the estate plan is not coordinated. So you did a special needs trust, but you never did your will that directs the share for that beneficiary to the trust, or you never did a trust, or you didn't set up your accounts payable on death to the special needs trust. The other thing that is a myth, I think, in the community is if your person, there was a third-party special needs trust, money went into the trust, because Altex is not the beneficiary, that you did not have to tell Altex about it. If there is any money in a trust for your person who's on SSI or DDD and Altex benefits, or subsidized housing, or the SNAP program for food assistance, all assets in that beneficiary's name or in a trust that benefit that beneficiary must be disclosed to those agencies. Now, those shouldn't be counted resources. They shouldn't impact eligibility, but only the federal and state government get to make sure that the work done by the lawyer was appropriate. And 99.99 times, there is no impact and no letter even comes back. You sent it, you never heard, you have your little green card to show that you disclosed it. In 99.99% of the time, if something comes back, it was a mistake and has to be clarified. And in the same percentage of time, even if something was not perfect, almost all the time it can be fixed, whether that's through a court order or the trust allows for an amendment to fix whatever the problem is and get that clarified. What happens when you don't tell the agency that your person received money that's sitting in their bank account or got transferred to your account because you thought that was easier, and then they find out about it, maybe through a tax filing or some other process, is that particularly for SSI, it may be that all of the benefits received by that beneficiary from the time that the wrong thing happened made them ineligible, and 100% of those benefits need to be paid back. Now, before you freak out, for Social Security, if they're going to continue to be eligible going forward because the problem got fixed, Social Security cannot collect more than 10% of the maximum benefit. So if they were getting $975 is the maximum SSI payment, and your person owns $10,000, Social Security will only reduce the going forward SSI payment by $97, 10% of that $975, or $97.50. So it's not as if you have to come up with money you don't have, but reporting when you're supposed to will avoid those issues, because most of the time, as I said, they can get resolved through a court order or an amendment to a document. So make sure that's happening. If you have people on SSI or Social Security disability, remember you have to report monthly using the Social Security app. for what those wages are so that they can make sure that your person is still eligible. For SSI earned income, the first $85 of earned income does not impact the SSI payment. Thereafter, for every 50 cents earned is 50 cents, for every dollar earned is 50 cents off of the SSI payment. If you are giving cash to your person on SSI, that is unearned income. That is a lovely gift. Anything over $20 in a month is a dollar for dollar offset. So there would be never a reason to give a person on SSI ever more than $20 of cash because it's a dollar for dollar offset. So you gave them a dollar and the government takes away a dollar. So be conscientious. You can use something called a TrueLink card. Again, I have no financial connection, but it's actually in the regulations for Social Security. And you go to truelinkfinancial.com. They're even really good, I hear, for kids who are not fiscally great. So maybe you don't want to give them a credit card when they went to college. You don't want to give them a debit card. You can give them a TrueLink card, and you can load funds on there of whatever amount you want. And then you can see where the funds are spent. You can block liquor stores. You can block cash transactions. So you can have a little bit of control over how the funds are used, but they hold the card so it can be used up to the amount that's been loaded onto the account. So another question in the case of a person on, it says SSI disability benefits. So SSI and Social Security disability benefits are completely separate programs. They're funded differently and they have different eligibility criteria. But we'll keep going and then we'll figure out if that matters. They should be eligible for SNAP, again, what we used to call food stamps. What can be done if and when they don't want to apply for SNAP, yet they could really benefit and would likely qualify? The person is their own, in charge of themselves, or not under guardianship or conservatorship. Obviously, they might have some issues, which is why they're qualifying for Social Security benefits. So you can't force people to take services. You can't force people to be unhoused, regardless of their mental health status, for the most part. So I think part of that may be a carrot and a stick. So if there's a special needs trust and this person would be eligible for food assistance, you could say you would be eligible for food assistance, so the trust is not going to pay any of those costs. You can pay for it out of your own Social Security, or you can apply for the food assistance, and that would give you more money to pay for food. But I don't think you can force them. And honestly, even if you applied on their behalf, it doesn't mean they're going to use that debit card when they go to the grocery store. I think that the government has done a really nice job of making the debit card for food assistance. It looks like any other debit card. It's not like when we were younger and they literally had stamps. And so you'd be in the grocery line and that person would be pulling their stamps off and giving them to the cashier, announcing to the whole world, I'm an indigent person and I'm using, services in order to buy my food. So this feels much more respectful, that it looks just like any other debit card. So maybe that would push them in the right direction, but I don't know how successful you will be in applying for that person if they are, for whatever reason, completely opposed to using the programs that could give them some services at no cost and help them to pay for services so there would be more money for other things. This person says that the application for the SNAP feels pretty burdensome to that person who's a bit paranoid to start with. So maybe you can sit with them when you're next in town and go through the application process together and help them get that filled out. There also should be benefits counselors through the Department of Economic Security, which it's my understanding oversees the SNAP program in Arizona. So the applicant may be able to call and make an appointment and have somebody help them with the application if you're not going to be together in order to do that, either over the phone or on the computer at the same time. I have to say that I am an old person, I guess, and my niece is not an old person. And I was trying to buy airline tickets for her to come visit us. And I'm like, I don't know how to fill all these things out for you. And of course, she could FaceTime or share her screen, or I could do the same thing. And so she would tell me, in this box, put this, in this box, put this. So there's probably a way to do the same with regard to the application process. So just some ideas. So it is hard to imagine, but we are at the end of our hour. And I so appreciate so many of you joining me today. It is an absolute pleasure and honor to serve you or have the opportunity to do so in the future. So I thank you so very much for trusting us to help you through some pretty difficult times often. And we look forward to seeing you for our next webinar when that happens in January. So happy holidays to everybody. Have a healthy new year, and we'll see you on the other side. Thank you. Bye-bye.